Show me the law. I want us to show me the law. You don't know law. They are demoting you. You are writing rubbish. Show me the law. Unaddressed affidavit. You say you go. Are you doing their job for them? God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask for what? Where is the law?
Let's go, please.
Where is the law?
Let's go.
Lawyers, judges, don't even know if we are with each other. I'm so disappointed that I Yoruba engage in this. It's good we say it. From the Chief Justice, from the Attorney General, from DSS, from lawyers, judges, they are all Yoruba.
Nnamdi Kanu refuses Abuja transfer. Why was he sent so far away in the first place? Nnamdi Kanu once asked the Federal High Court to transfer him from the Sokoto Correctional Centre to Abuja. The court did not grant the request when it was first presented. Now, according to his wife, arrangements were later made for that same transfer, but Nnamdi Kanu declined to leave Sokoto. At first, this sounds confusing. Why would a man reject the very transfer he had previously requested? But perhaps the deeper question is not simply why Kanu said no. Perhaps we should ask, why was he taken from Abuja to a correctional facility more than 700 kilometers away in Sokoto in the first place? Who selected Sokoto? Was the effect on his appeal, access to lawyers and family considered? And has this case reached a point where Nnamdi Kanu no longer trusts even an arrangement that might appear beneficial to him? Welcome to the Critical Lens Africa, where we go beyond the headlines and examine the deeper questions. Nnamdi Kanu is the leader of the indigenous people of Biafra, commonly known as IPOB. He was first arrested in Nigeria in 2015 and later granted bail in 2017. After security forces raided his family home in Abia State, he left Nigeria while his trial was still pending. In June 2021, Nnamdi Kanu was detained in Kenya and forcibly returned to Nigeria without passing through a recognized extradition process. His lawyers described what happened as an extraordinary rendition, an unlawful seizure and transfer across international borders. In October 2022, the Nigerian Court of Appeal discharged Nnamdi Kanu and ordered his release, holding that the manner in which he had been brought back from Kenya violated Nigerian and international law. However, in December 2023, the Nigerian Supreme Court overturned that decision and ordered that his trial should continue. The Supreme Court acknowledged that Nigerian security authorities had violated his rights during his arrest and return from Kenya. But it held that the unlawful conduct did not remove the Federal High Court's authority to continue trying him. Then, in June 2025, another major judgment came from Kenya itself. The High Court of Kenya ruled that the abduction, secret detention and forcible removal of Nnamdi Kanu from Kenyan territory were unconstitutional and illegal. The Kenyan court found that his fundamental rights had been violated and awarded him 10 million Kenyan shillings in general damages against the Kenyan government. That Kenyan judgment did not produce the Nigerian Court of Appeal decision because the Nigerian ruling had already been delivered almost 3 years earlier. But it independently confirmed one of the central arguments Kanu and his lawyers had made for years. He was not lawfully extradited from Kenya. He was unlawfully seized and forcibly returned to Nigeria. When courts in two different countries recognize serious violations surrounding the return of a defendant, should the justice system not exercise exceptional care before sentencing that same person to spend the rest of his life in prison? Instead, after the Nigerian Supreme Court restored the trial, the case returned to the Federal High Court. After several delays and changes of judges, Justice James Omotosho took over the proceedings. Nnamdi Kanu faced 7 terrorism-related charges. He denied the allegations and repeatedly challenged the legal foundation of the prosecution. His central argument was simple but serious. Show me the valid written law under which I am being tried. Kanu argued that the earlier terrorism legislation cited against him had already been repealed by the Terrorism Prevention and Prohibition Act of 2022. The prosecution maintained that transitional provisions in the newer legislation preserved legal proceedings that had already begun under the former law. Justice Omotosho rejected Kanu's challenge and allowed the case to proceed. Kanu later declined to present a defense, maintaining that the charge sheet did not disclose offenses founded upon a valid written law. On the 20th of November 2025, Justice Omotosho convicted Nnamdi Kanu on all 7 terrorism-related counts and sentenced him to life imprisonment. The prosecution had requested the death penalty, but Justice Omotosho said he chose life imprisonment instead as an act of mercy. The judgment did not end the controversy. It intensified it. Kanu and his supporters insist that a person cannot lawfully be convicted under legislation that has ceased to exist. The trial court took the position that the case survived under the transitional provisions of the 2022 law. That disagreement is now one of the major issues surrounding his appeal. The appellate court must determine whether Justice Omotosho correctly interpreted the law or whether Nnamdi Kanu was sentenced to spend the rest of his life in prison under provisions that could no longer lawfully sustain his conviction. This is not a minor technical argument. A life sentence takes away a person's freedom for the remainder of his natural life. Therefore, every charge, every procedure and every section of law relied upon must be constitutionally sound. Whether one agrees with Nnamdi Kanu's politics or not, the law must never be stretched, selectively applied or used as an instrument of humiliation. After the judgment, Kanu was moved from Abuja to the Sokoto Correctional Centre. According to documents presented in his later transfer application, Justice Omotosho's sentence permitted his detention in any correctional facility in Nigeria except Uchechi Correctional Centre. The available court reports do not clearly establish who made the final administrative decision to select Sokoto. That distinction matters. The public deserves to know. Who specifically chose Sokoto? What security, administrative or legal reason justified taking him so far from Abuja? Was that decision made by the court, the Department of State Services, the Nigerian Correctional Service or another authority? And did anyone consider the effect that such a distance would have on his constitutional right to prepare an appeal? Nnamdi Kanu stated in his application that Sokoto was more than 700 kilometers from Abuja and that the distance made personal contact with the court registry, legal consultants, relatives, and those assisting with his appeal extremely difficult. A life sentence is already one of the gravest punishments the law can impose. Was it then necessary to add geographical isolation, placing him far away from his lawyers, his family, and the courts where his appeal would be pursued? Justice should punish only according to law. It should not become punishment through unnecessary distance, isolation, or additional hardship. These questions do not, by themselves, prove tribalism. There is no publicly established evidence that Sokoto was chosen simply because Nnamdi Kanu is Igbo. But when a politically sensitive prisoner from the southeast is moved to a distant correctional facility in the far north without a clear public explanation, suspicion of political or regional bias will naturally arise. A justice system must not only be fair, it must also be seen to be fair. When its decisions create the appearance of selective punishment, the authorities have a responsibility to explain themselves. After arriving in Sokoto, Nnamdi Kanu applied to the Federal High Court to be transferred to Abuja or to another correctional facility closer to the city. His reasons were understandable. He needed easier access to those assisting him with his appeal. He needed contact with the relevant court registries. And his family needed a more realistic opportunity to visit him. On the 8th of December 2025, Justice Omotosho declined to grant the request immediately because it had been brought without first hearing from the federal government. The court ordered that the processes should be served on the government and the prison authorities and fixed the matter for a later hearing. When the matter returned to court in January 2026, the Legal Aid Council lawyer handling the application withdrew, citing irreconcilable differences. The application was then struck out as incompetent. Therefore, the court did not make a final decision that Nnamdi Kanu must remain in Sokoto permanently. The first request was not granted without hearing the other parties, while the later application was withdrawn and struck out on procedural grounds. Now comes the unexpected development. According to Kanu's wife, Uchechi Okwu-Kanu, she continued pursuing her husband's transfer through diplomatic, consular, and other official channels. She said her concern was humanitarian, legal, and practical. The distance made family visits difficult. It complicated legal consultations. And it made access to his case unnecessarily burdensome. She said she later received confirmation from a case handler at the United Kingdom's Foreign, Commonwealth and Development Office that arrangements had been made for Nnamdi Kanu to be transferred to Abuja. But Kanu declined to move. According to his wife, he believed the earlier handling of his own court application had been manipulated. From his perspective, there had been no legitimate reason for the court not to grant the transfer through the legal process he had followed. He therefore chose to remain in Sokoto rather than accept a transfer arranged through a different process. She also said he preferred that, whenever he eventually regained his freedom, he would leave directly from Sokoto and return home. A later statement from his family gave an additional explanation. The family said Nnamdi Kanu would not leave Sokoto for Abuja without a court order because his detention in Sokoto had become a live issue in his appeal. They argued that accepting a voluntary administrative transfer could later be used to suggest that he had abandoned that aspect of his case. According to the family, the refusal was therefore not about comfort. It was a calculated legal decision. Seen from that perspective, his refusal may not have been stubbornness. It may have been the decision of a man who no longer trusted the process and did not want an important legal issue quietly removed through diplomatic intervention. He had first asked the court for a transfer. That request did not succeed through the procedure placed before the court. When another arrangement later emerged through diplomatic or administrative channels, he may have feared that accepting it would weaken his argument concerning why he was sent to Sokoto in the first place. His position appears to be that any transfer should be formal, transparent and backed by a lawful court order. The greater question, therefore, is not why a prisoner who has repeatedly complained about injustice has become distrustful. The greater question is why the Nigerian justice system has allowed this case to reach a point where even an apparently beneficial transfer is viewed with suspicion. From his forcible return from Kenya, to the Nigerian Court of Appeal judgment that discharged him, to the Supreme Court decision that restored the trial, to the Kenyan judgment declaring his abduction and removal illegal, to the dispute over repealed legislation, to his life sentence, and finally, to his transfer from Abuja to distant Sokoto. Every stage of this case has created another layer of controversy. Justice must never be influenced by ethnicity, political pressure, personal dislike, or the popularity of the accused. A judge may disagree completely with Nnamdi Kanu's ideology. The government may oppose the campaign for Biafra. Many Nigerians may reject his method or statements. But none of that removes his right to a fair trial, valid charges, meaningful access to the appeal process and humane treatment. The true test of justice is not how the law treats those whom the government finds agreeable. It is how the law treats those whom the government considers difficult, controversial, or threatening. If the law relied upon is valid, let that validity be demonstrated clearly. If the evidence is sufficient, let it withstand independent appellate examination. If Sokoto was selected for a legitimate reason, let the authorities explain that reason publicly. And if mistakes were made, justice demands that they be corrected, not defended simply to protect the reputation of institutions or individuals. Nnamdi Kanu's appeal should be considered strictly on the law and the evidence. No political pressure. No ethnic sentiment. No desire to make an example of him. And no attempt to use distance or isolation to weaken his ability to challenge his conviction. So tell us, why was Nnamdi Kanu taken from Abuja to Sokoto after his sentencing? Was his refusal to return to Abuja an act of distrust, a legal strategy or a defense of principle? And can Nigerians confidently say that this case has been handled without political or regional bias? Share your opinion respectfully in the comment section. Please like this video and share it so that many others will be informed. Also, subscribe and turn on the notification bell so you will be notified whenever we upload a new video. This is the Critical Lens Africa, going beyond the headlines.